Speaker, sir, I rise to move the motion for consideration of the Waqf Amendment Bill 2025 and Mussalman Waqf Repeal Bill 2024.
The bill is passed.
गांधी की तरह इस कानून को फाड़ता हूं। ये अनकॉन्स्टिट्यूशनल है सर। इस देश में झगड़े पैदा करने का काम बीजेपी करना चाहती है मस्जिद और मंदिर के नाम पर, इसीलिए मैं इसका कंडेम करता हूं और मैं आपसे गुजारिश करता हूं कि मैंने अपने 10 अमेंडमेंट दी है, आप इसको कबूल करिए। सर, मुझे बोलने का मौका दीजिए।
Who really controls the Waqf land, the community or the state? And why has the 2025 Amendment Act led to legal and public debate across the country? The Waqf system in India manages thousands of properties meant for religious and charitable use within the Muslim community. But over the years, there have been growing concerns from mismanagement and corruption to disputes over ownership. The law was passed swiftly in the Lok Sabha on April 3rd, in the Rajya Sabha on April 4th, and it received presidential assent the very next day. But just as quickly, it landed in the Supreme Court. A 3-judge bench led by Chief Justice Sanjeev Khanna is now hearing petitions challenging the new law. On April 17th, the Solicitor General Tushar Mehta, representing the centre, requested a week to respond. The court granted that, but also took note of growing concerns, particularly over the inclusion of non-Muslims in Waqf boards and the potential denotification of Waqf properties, especially those related to Waqf by user. For now, the government has assured the court that no appointments will be made under sections 9 and 14 and that no Waqf properties will be touched or reclassified. The next hearing is scheduled for May 5th. But the questions remain, and they run deep. Does the Waqf amendment help improve management, or does it give too much power to the government? Does it interfere with religious freedom, minority rights, or protect public interest? To help us make sense of this, we have with us today Professor Faizan Mustafa, one of India's most well-known legal experts and the Vice Chancellor of Chanakya National Law University. He has written several books and published around 100 papers in India and abroad, and brings deep knowledge of constitutional law and minority rights to this conversation. Thank you so much, sir, for joining us today. And of course, the first thing that I want to ask you is that what is your view on the recent Supreme Court order on the Waqf Amendment Act?
You see, I am a little surprised because generally when the constitutionality of any law is challenged, on the day one, the court merely says issue notice and gives 8 weeks or 12 weeks to the central government to respond to the petitions. In this case, on the very first day, which means day before yesterday, there was substantial arguments made about the problematic questions. There were a lot of questions coming from the bench, and therefore it seems that the judges had come very well prepared. They had read all the petitions, they were aware of the contentious provisions, and they made life of the Solicitor General little difficult because he did not anticipate, like me, that on day one he would have to defend some of the provisions. As an intelligent advocate, he sought time, and then when he appeared yesterday, he was more prepared. And looking at the mood of the court, he conceded ground. So rather than getting a stay from the orders of the court, Solicitor General must have advised the government, and government had accepted his advice that let us say that till the hearing of this matter, we are not going to appoint non-Muslims to the Central Waqf Council or the state Waqf boards, or the district magistrate will not exercise his powers under the new law, or Waqf by user is not going to be disturbed. So I would say this round of 2 days hearing has gone in favor of the petitioner, which is unusual because normally the court starts with the presumption of constitutionality of a law. So the court presumes that any law passed by the parliament or even by the state legislature is constitutional because members of the parliament and members of the state assemblies, being a lawmakers, are aware of constitutional provisions. And the burden on anyone who challenges a validly passed law is very heavy to prove either that the parliament did not have the jurisdiction in this case or that this law is in violation of any fundamental right. So I believe that these arguments have gone well. The court, to me, appear to be fully aware of the central issues involved in this round of litigation, and reacting to their anxieties, the government did well by conceding some ground on the second day.
So legally speaking, this was a interesting game to see how petitioners and the central government had done, and it looked like the petitioners were far more prepared this time.
Generally, because like anybody else, he also anticipated that there is going to be no hearing on the first day. I had said it in number of programs that nothing is going to happen except notice being issued. So Solicitor General was well within his right, like me, to presume that nothing much is going to happen.
Also, just speaking legally, does the Waqf Amendment Act trample the right to equality and the right to pursue religious practices? Because that's what the opposition has been mostly putting their argument in that reasoning. So if we go from legal perspective, does it really trample these rights?
You see, we need to understand what is Article 14 or right to equality under Indian Constitution. So right to equality does not mean at all that everybody is to be treated equally. It means law within the class will be same. So likes are to be treated alike. Unlikes are not to be treated alike. Therefore, people who are similarly circumstanced will be treated alike. If there are differences, law permits classification. It only forbids class legislation. You can classify people if you are making a classification which is reasonable, which is rational, and it has a rational object to achieve. The classification is based on intelligible differentia. You can have different laws for different people. There can be a law even for one individual if that individual constitutes a class in himself. Now, if this is the law, we should also understand that our courts have said that right to equality includes right against arbitrariness. Therefore, any classification which is not rational, any classification which is based on religion or race or caste or sex or place of birth, which does not have any rational object to achieve, which is not based on intelligible differentia, that people who are taken in and who are left out, that there are no major differences between them, then such a classification would be arbitrary. And if it is arbitrary, it would be violation of right to equality. The argument which the petitioners are making and the argument which a number of legal scholars have also raised about the new act, that the religious and charitable property of Hindus and Muslims is to be treated alike. And if this is so, since the Hindu temple boards, you don't permit non-Hindus to be the members, in the Waqf boards, you should not bring non-Muslims as members. As you know, my position has been that as someone who believes in the value of a diversity, I had personally welcomed this provision. I still believe that if there are good Hindus who can contribute meaningfully to the deliberations in the Waqf board, a central Waqf council, then such an expertise will help the Waqf board improve its efficiency. As I have been repeatedly saying that a minority institution should have overwhelming minority teachers or overwhelmingly minority people in the administration is negation of Article 30. Article 30 does not demand this. You should have ideally majority of students from that community which has set up that educational institution. But if you are setting up a minority medical college, you need a professor in neuroscience, and you don't have a neuroscience professor in that community, then let a non-minority person be appointed there. So, same thing I would say here, that if in Waqf board non-Muslims do become a member, of course they should not become a majority, but some presence of them, in my opinion, will be good rather than bad for the efficiency of the Waqf board, provided better people are appointed. Currently, when you have all Muslim Waqf boards, most of the members of the Waqf board and the Central Waqf Council are nominated by the government. Waqf board is a government body. What kind of people government has been appointing? Corrupt, irrelevant, inefficient. If Waqf board has not worked efficiently, who is to be blamed? Governments which have nominated people to those Waqf boards. So if government nominate their own chamchas and their own party people, then whether you have new law or you have old law, whether you have Muslims, you have non-Muslims, nothing is going to improve.
So the Right to Equality Act is more about equity rather than just equality in picture, and on that basis, it's
So equity is a superior concept than equality. Equality is legalistic. Legalistic in the sense that we are talking of equality amongst equals. Equality will be a slightly higher level of equality, which no, our equality also, there can be a formal equality and there can be substantive equality. Say if you have 4 breads and 2 people, if you give them 2 breads each, it is formal equality. But one may need only 1 bread. Have a small tummy, doesn't want to eat much. The other may be very hungry, maybe having big tummy. He needs 3. If you give 2 to each, one is wasting it and other is still hungry. And therefore, equality may take into account past disadvantages. And therefore, it may treat people differently. Treating people differently may become the part of equality. This is what the reservation scheme is all about. That people who have been historically marginalized, if they are treated equally with the upper caste, they will never be able to qualify. Therefore, we discriminate in their favor. So the idea of substantive equality may be closer to equity, but the idea of formal equality is basically a legalistic concept.
right. Thank you for explaining. So here we want much more qualified people. It's not about which religion they come from, but of course, the majority could be of Muslims, but having non-Muslim members, in your opinion, is a welcome change if they're qualified enough to hold the Waqf board.
qualified, honest men of integrity, appointed on merit rather than appointed because of the party affiliation, Sangh affiliation, organizational affiliation. That should not happen. People should be appointed for any government position only on merit.
Fair enough. Also, right now, was there a necessity to bring the Waqf Act because it was recently amended? Was there really a need to have amended and
I personally don't feel so. I really don't feel that there was such an urgent need to bring a law because law was not bad. What was bad were the kind of people who were appointed under that law, under the Central Waqf Council or under in various state Waqf boards. So changing law is an easy option in any democracy for any elected government which has a majority. You will issue a whip, your party members will vote for you, the law will be passed. India is over-regulated society. We over-legislate because that is easy. Improving the economy of the country is more challenging. Changing the patriarchal attitude of our society is more challenging. Curbing the hate is more challenging. Giving jobs is more challenging. Governments generally opt for easy option. Easy option is that they tell their council, look, we have passed a law. But passing a law is not going to really improve the ground situation.
So it's just politics at play. If we put it in simple things, it's mostly politicians passing the law, but it might not really have an effect in the society, in the ground.
Now, I give you an example. Prevention of corruption law is old. Prevention of food adulteration law is old. You have passed so many laws. Even under UPA, what is your conviction rate? How many convictions ED has got? So having stringent laws on the statute book is not going to really bring any radical change on ground if the laws are not properly implemented. You know, we say now, the best government is one which governs least.
So, even the argument that government has made about this act that, property and its management would be much better, the corruption would go down, Waqf properties would be much more regulated. Do you think that the amended law would rectify this if, as like they have said, would that be true? If the law...
You see, I never doubt intent of the government. As a legal academic, I believe presumptions should always be positive. So I am inclined to believe that the government has valid reasons to bring this law. They are well intentioned. I have written that some of the provisions of this law are good. The problem is that how do you improve efficiency of Waqf board when you have weakened it? Waqf board is the regulator. We have weakened the Waqf board by reducing its powers drastically. How can it improve efficiency? The adjudicatory authority of Waqf properties was the Waqf tribunals. Drastically reduce its powers and its jurisdiction. So the adjudicatory authorities' powers have been reduced, regulatory authorities' powers have been reduced. How can then it improve? And therefore, I would be very surprised, very, very surprised, if law delivers the promised goals, because any Waqf board which is not powerful enough, and even financially it has been weakened. Under the old law, each Waqf was contributing 7% of their profits to the Waqf board. Under the new 2025 Act, it will contribute only 5%. So financially weak, administratively weak, adjudicatory weak, and we say it will improve the efficiency. This defies logic.
Absolutely right. So there would be a question when the act is fully implemented, we see how it works, but logically it doesn't make sense that the goals that it had promised to achieve right now.
But I would be surprised if it delivers its promises.
Also, speaking legally, help us understand that is it that several other Muslim denominational institutions like graveyards, orphanages that are registered as trust and not as waqfs, will that not cover this ambit? Will it not come under the ambit of the 2025 Act?
No, if anything is registered as a trust, then of course the trust law will apply. But there is a difference between the trust and the waqf. A trust can be in favor of the one who is creating the trust. A waqf cannot reserve any benefit for the waqif who is creating the waqf, except under one school of Islamic jurisprudence, where he may reserve something for his benefit as well. So both laws are different, even though the trust law, the British trust law, has also borrowed from Islam. So, but still both are different.
So we do want that.
The property under Waqf law is given and dedicated to God. It doesn't remain the property of anybody. So it's a slightly different concept than trust, even though few things look similar, but they are not identical ideas.
So the charities made and given in the name of trust would be different, legally would be dealt differently as compared.
No, I don't think that any property which has been created as a trust is not going to be affected, but I will be very surprised if any dargah or any graveyard has been created as a trust. Unlikely.
Also, when we talk about this, then how does the law deal with the Daudi Buras community, their charity, which may not be directly given as waqf?
You see, the Daudi Buras are a section of Shia sect of Muslims. Extremely rich, very religious, very conscious of their religious identity, have done well in terms of businesses. Within them also, there are some conservatives, there are some liberals. For instance, Asghar Ali engineer was a liberal, but there was an attack from the conservative Daudi Buras groups. Asghar Ali engineer was attacked. They also excommunicate people like Sikhs do the Tankhaiya, and their power of excommunication by Sayyidna was upheld by the Supreme Court. Within the Shia Waqf board, Daudi Buras were already covered. Now the new law is proposing that if their number is substantial in any state, there can be a third Waqf board exclusively devoted to Daudi Buras. As you have a Sunni Waqf board, you have a Shia Waqf board, you can have a third also as Daudi Buras Waqf board, or Agha Khani Waqf board, which is another sect of Shias. So Daudi Buras community people, they went to the Prime Minister, they congratulated him and they thanked him, expressed their gratitude that they can now have a Waqf board of their own. But they were already covered. But this is not going to drastically change situation in most part of India because they are confined, say, to Mumbai or to Gujarat. I don't think that in any other state there will be enough numbers for them to have a Waqf board of their own.
So it might not make such a great difference as we are assuming it to be. Also, regarding this new act, there is one more question, that property that comes under the Ancient Monuments Act that cannot be used as waqf. Is that true legally, like, or there is a misconception here?
You see, we really don't understand the scheme of laws, and we live in a post-truth era. So truth has become irrelevant. Any kind of myths can be perpetuated, propagated, and people start believing them as gospel truths. There is one law, Ancient Monuments and Archaeological Sites Act, and there is another law called the Waqf Act. The principle of law is that if there are two laws, they should be harmoniously construed. So we should try to give effect to both the laws. Now, with what properties the Ancient Monuments and Archaeological Sites Act would deal? Any property which is more than 100 years old, it can be declared as a protected monument. Now, if a property is declared as a protected monument, the responsibility of maintenance of that property falls on the central government. So central government has to protect it. But the archaeological monument, Ancient Monuments and Archaeological Sites Act itself makes a provision that if a protected monument is being used for a religious prayer, for a religious purpose, it cannot be used for any purpose other than that religion. Say if there is a mosque, let us say the Jama Masjid of Delhi, which is already about 400 years old, it is used as a mosque where prayers are taking place. So you cannot have worship there. You cannot have Christian prayers there. It is a protected monument. If something gets damaged, the mosque administration cannot repair it. It will be repaired by ASI, Archaeological Survey of India, there, because we need to protect that architecture. We need to protect that building. You know, recent Sambhal case about the Sambhal Mosque. Every year during the month of fasting, all mosques are painted. So people wanted to paint the Sambhal Mosque. Now the ASI objected to it. The matter went to the Allahabad High Court. And Allahabad High Court said that you never objected to it. What damage is going to be there to the building if it is painted? An Archaeological Survey of India was not able to convince the court that this will get damaged or that will get damaged. And ultimately the court said, let it be painted by the mosque committee. So just because a monument is a protected monument does not change its character as a waqf. Even my personal house can become a protected property. What if it becomes a protected property? Some of my rights will get reduced because government then will get a say in terms of maintenance of it. It may put some entry tax on that this is an entry fee. There are these timings on which, people can come and have a look at it like that. But it cannot allow worship or prayer of a different religion. That is there in the archaeological, Ancient Monuments and Archaeological Sites Act itself.
The purpose is never going to change. There might just be a control here and there. The functioning of it might change a bit from the government side, but the purpose is not.
In fact, then government gets the responsibility of maintaining it and protecting it. And therefore, in the demolition of Babri Mosque, the government was at fault. It was a protected monument, over 450 years old. They were supposed to protect it. They failed in protecting it. It was one of the rare pieces of Sharqi architecture.
Also, the last question before we end. In these recent years, we have seen that as soon as an act is passed, as soon as it's been passed by both the houses and the president assent is given, it directly goes to the court on whether it's because of its legislature. It has happened with the Kashmir amendments, the citizenship amendments. And so, what does this tell us about the overall functioning of the legislature and the judiciary in our country right now?
Good question. I have been writing on this, that big ticket reforms should have wider consultation, and ideally we should try to have consensus on them. We should evolve consensus. Government has a duty to evolve consensus. Opposition has a duty not to act as an obstruction in way of a reform. If reform is done for the purposes of reform, devoid of politics, devoid of political goals, it would be easy to have a consensus. If you get consensus, law can it still be challenged, but not like this, like CAA or 370 or like Waqf bill. I give you an example. 2014, the Modi government started with a big ticket constitutional reform by passing a constitutional amendment to establish National Judicial Appointment Commission, NJC, unanimously passed in Lok Sabha. Almost unanimously passed in Rajya Sabha. The only dissent was from veteran lawyer, great late Ram Jethmalani. It was still challenged and struck down. So challenge of a law is not something which is prohibited under law. Anyone can challenge. About the Waqf bill, I had to tweet this. Too many applications. There is a mad race to file an applications. Supreme Court is not going to be impressed if you file 1,000 applications. One well-drafted application is good enough. One well-drafted petition is good enough to
That
get a
covers all the
law
points.
struck down.
Yeah.
Isn't so? Yes. So I really don't know why so many petitions are filed, but probably one reason is that the political parties are not on one page, on the same page, on the question of a law reform. On the question of a law reform, the initiative should come from the government, opposition should favorably respond, and both should try to evolve a kind of a consensus, reduce their differences, remove the contentious provisions so that everyone owns up that law. When a new big ticket law reforms happen, there should be all round celebration in the country that we have reformed this law. If that is not happening, it would also affect the efficacy of law. Forget about the legal challenge in the court.
So I think at this point, both the opposition and the government has to come together and discuss it mutually so that it's more functioning and saves the time of everybody eventually.
Yeah, that's what I said.
Thank you.
I said the same thing.
Thank you. Thank you so much, sir.
All right.